This your voice is always shocking me.
I've made you the host already, sir.
Yes, I'm recording. Okay, we are back to being the host. Let's go. So, law of banking and negotiable instruments. Today, we are looking at the types, nature, and legal effect of bank accounts. So, little by little, we are stepping our foot fully into banking law. And you will see that when you saw these topics in the beginning, they looked like they were kind of, Greek, all these things. How are we supposed to know them? But you're going to see little by little, these things are becoming easier to understand. They are really not that difficult. Okay. So, what are bank accounts? Bank accounts, as we stated in our class some days before, is the starting of the banker customer relationship. You cannot say you have a relationship with a banker if you do not have an account with that bank. The bank must be able to see your account and deal with you as an account holder in order for them to be fully seized of the fact that you are in a relationship with them. It's just like you cannot have a marriage until you go and show yourself to the family of the woman. So also you cannot say you are a banker, you are in a banker customer relationship if you do not have an account to the bank. So by the time we finish this class, you would have learned exactly what is expected of you as a customer of a bank. Uh, how, for example, bank accounts are supposed to run. What are the current modern forms of bank accounts? Okay. So with your kind permission, I will proceed. So what what is a mandate? First of all, before we talk about accounts, we must have to talk about mandates. What is a mandate? A mandate is a document that opens an account. A mandate is that original document that you share with a bank when you enter there to open an account. If you remember, there are a series of things that banks give you and you are just signing, signing, signing. Many people don't read it. But one of the things you don't know is that a mandate reflects the nature of the relationship a bank wants to have with you. It is the authority, the legal authority that forms the basis of a relationship between a banker and his customer. So, in that mandate is a set of instructions that you give to the banker that will regulate the conduct of your account, how the banker is going to accept deposit from you, whether the bank is going to regard your account as a deposit or a savings account, as a current account, or as a whatever it is that you talk about. Today, mandates dictate the kind of a mandate dictates the kind of relationship, the way a bank will collect money from you. I say this because many of you think that the only way to put money in the bank is to go and place your money over the counter or to do transfer. However, I can assure you that there are people, right, who the bank goes to their business to carry money from them on a Saturday night. You don't know, but there are people like that. The bank carry a bullion van, goes to this person's business, collects money from him. The rest of us have to go to the bank and beg them to take our money. And the cashier will be looking at you like you killed Jesus. But some other people, the bank have to go to their business because of the volume of the cash they come up with. Because telling them to transfer to transport that money to the bank sometimes may be costly. Sometimes it may it may be very expensive, and sometimes because of the relationship they have with the bank, it's just more convenient for the bank to be the ones to convey that money. What makes up that kind of relationship is the kind of mandate that they have. Now, there are other documents that you can refer to as a mandate, for example, a check or things of that nature. But one thing you must know is that a check and other further documents that will regulate the banker and customer relationship must work within the legal ambit of the general mandate that the customers have with the bank already. So, what are the features that we'll look out for in a mandate? First of all, a mandate must not be inconsistent with legal principles. That is to say, anything that the law requires a type of account to have, the mandate must not traverse that requirement. If, for example, a bank account is required by law to have two signatures because of the nature of the bank account it is, you cannot by hello? I see my network has issues. Can you hear me? Um, Hello? Anybody home? I see I'm still recording. Hello?
We can hear you now, sir.
Yes. I feel like my village people sent some things against me.
Okay, but we can't see your screen again.
Yes, you have to make me host again so that I can share.
Yes, but you're still recording though.
I know. Okay, I want to apologize for all that's gone on. I don't know what is going on today. And please allow this to happen for now. Okay. So, yes, what are the features of a mandate? First of all, it must not be inconsistent with legal principles. That's what I was explaining. The document that opens an account must not be inconsistent with legal principles. The mandate must not be inconsistent with the customer's binding documents, which the bank is aware of. Now, this usually arises, for example, where a bank and is having a relationship with a customer that is a legal person. And if, for example, a legal person wants to open an account, and this account that he wants to open requires him to drop the constitution of that he has or his what we call memorandum and article of association. What happens is that where the memorandum and article of association says that one person, probably a president should sign to withdraw money for the organization. The bank cannot agree on a mandate that will give the treasurer the right to withdraw money. So if the bank is aware of a specific requirement, which is a binding document within its customer's setup, it cannot agree on a mandate that will be inconsistent with that binding requirement. Another thing is that a mandate must be in writing. You cannot just go to the bank and say, take my word for it. I need this account. And the bank is like, yeah, we'll give you this account. No. It must be in writing and signed appropriately. And then the mandate must contain clear information which the bank requires. What are some of that information? Of course, the person's name, address, occupation, etc. Now, if, for example, those who are supposed to present tomorrow do not listen to this class, they will not know this because this is not in the textbook. All right. So, but if they listen to it, they may know about this and they will talk about it. I'll be willing to see how they will navigate this if, for example, they do not show up in this class. Also, a mandate must be done on a standard form provided by the bank. So, what is a standard form? Now, some of you, of course, many of you just stepped out of secondary school. So, when you hear standard form, you are thinking mathematics, but no. Standard forms in law are documents that are created by organizations. So, for example, if you want to apply for governor's consent, there may be a standard form given to you by the Ministry of Lands or something like that. They produce a form in a particular format, a document that you will sign, a legal document you will sign that is in a particular format that all you have to do is to fill in your name or the particulars that are required of you. Okay, name, you fix name, and the things they want you to fix in. But the way the form is, nobody can change it. So that is how standard forms are. It is the bank that will prepare it. Why is it important for the bank to prepare it? It is important for the bank to prepare it because it is the bank that has the responsibility to make sure they have taken utmost attention in dealing with the customer. So if, for example, they are supposed to be liable on one or two things, since they prepare the form, they will know how to exclude their own legal liability. Okay? So there are other requirements that the mandate must fulfill, which is one, it must be clear and comprehensive. Okay? Also, a mandate must be approved by the parties concerned. A bank cannot create a mandate and be hoping that the other party will like it without the other party actually putting his signature into the document. Mandates are usually legally watertight in the sense that it removes responsibility from a bank, protects them adequately. Am I audible? Am I audible? Okay, thank you. So, um, mandates, of course, like many documents,
My data.
that is
It's working.
contractual in nature.
I think presentation.
Please,
The concept is in 2 weeks' time.
Bukumi Sani, we can hear
Now
you.
started our work. Maybe.
So you may want to mute yourself, or one that you can mute everybody. Mute everybody. So let me continue, please. Mandates are revoked by death, just like many contracts. Of course, by now you should have known that a mandate is also a contract. Bankruptcy, liquidation, lunacy, or oppression of law. Now, I'm going to ask you guys a question to know if you've been following or whether I've just been breaking. Why did I insert bankruptcy and liquidation here? Somebody should answer this question. I think there are about 15 of you here. Anyone? I'm going to mention any name I see here. Okay, I see a chat. Because mandates are made by banks. Okay, that's close, but not really it. And one thing you ask yourself is what kind of a person goes into liquidation? That's one thing you ask. Can a human being go into liquidation? No. A human being can be bankrupt, but you can't go into liquidation because you are not a. When I say legal persons, of course, you know there are two kinds of legal person. There is a living human person, an individual like you and me. Then there is people that are created by law, organizations that a statute creates. For example, the CBN and all these other organizations. They're also organizations that are created in lieu of a law. For example, organizations that are created under the CAC, companies um, and other forms of businesses, incorporated trustees and sole businesses. These are organizations that can be liquidated. So I'm just trying to let you know that a banker's customer does not have to only be a human being. It can also be incorporated, yes, non-natural legal entities going into liquidation. That is correct. Thank you very much. That's the way to put it, non-natural. Okay. Okay. Now I put this statement here. Check another document that you need from time to time are mandates, but they operate within the framework of the general mandate. So you have to know this. Okay. So what are the important issues you have to know when you want to walk into a bank to open an account? First of all, how old are you? If you are not up to the age of majority, okay, depending on the age, in Nigeria, I hope you know, there is no specific age of majority in Nigeria. There is no law that says that the age of majority is this. So for purposes of voting, age of majority is 18. For contract is 21. And for things of that nature. So it's expected that 21 years should be the age of majority before you can open a bank account. Now, if you are not up to the age of majority, there is also, it's possible for you to open an account, but it has to be a special account that allows you to handle what are called necessaries as a minor. Okay. Now, oh, in the modern days, of course, many of you are not up to 21 on this call. Okay. Apart from Clinton, that is like 27. Okay. Because that guy looks really old. I'm not sure anybody is 21 here. Now, if you notice the kind of account you open, you just need your school ID card to open an account. And the amount of money you can put in your account is usually limited. Okay. It's a special kind of account that banks open for you as a student, allowing you to withdraw money for your necessaries. Going to school is a thing that you must do. So giving you an account is not breaking this requirement. But if you want to have a full account that you can put, I just saw that my network connection is unstable. So if, for example, you can still hear me, can somebody just indicate if you can still hear me?
Yes, I have.
Okay. Another thing that we see here is that to open a bank account, you are required to have a reference. Reference are people who will stand for you to say, oh, okay, open an account for this person. The references are important and are usually two, but there is no law that regulates the amount of references you can have. In some places, the court have held, like in this case you have here, that one referee was enough. When you supply the details of a referee, the banks will have to confirm the signature of that referee with his bank and place a sample of that person's signature with them. The bank also has to know the accounts this person has and the money is inside them and whether they can actually stand for you as a referee. Okay. So if you do not provide sufficient reference, you should not be able to withdraw from your bank account. But the bank can accept deposits from it. And I remember what my lecturer in the law school told us. He said, if you put money on the neck of a goat and send him to the bank will not turn the goat back. If you put money in the neck of a goat, send him into a bank, that goat is not coming out with that money. But to take that money that you gave your goat to go and drop in a bank, you will hear me, because the now bank will now ask you that, sorry, the person who deposited this money is not a legal person. And you now be wondering, but this, you've already collected the money. Give us, okay, give the goat back the money. They say, no, a goat is not a legal person. Bank cannot transact with a goat. But you collected money from a goat. Yes, banks will collect money. No matter how it is, they will collect it. But to give it out, nawala. So that is something you will know. If you do not provide all the requirements that a bank needs, and you are dumping money in that account, the bank does not care. They will keep collecting the money. But before they give out kobo to you, they will make sure you fulfill every condition you have to fulfill. In fact, they will really like it if, for example, in the end, you are not even qualified to take your money again. Okay. Specimen signature. Specimen signature refers to your bank signature, your normal signature, a copy of it. You have to drop a copy of it with the bank so that when next you come to drop your signature, the bank will be able to match it. Now, usually, what constitutes a person's signature is his initials. So my name is Christian Sopuruchi. I can sign letters with CS. CS. However, because of forgery, it is required that people write their signatures in cursive so that it will be harder for somebody to recreate your signature and place it on a legal document. So that's why people are now required to put their signatures in cursive instead of just writing it in two words or two letters. Because if everybody were signing signatures by just dropping their initials, there'll be rampant cases of forgery. But if you sign it in a specific cursive that is just your mark, then it's very difficult for other people to reproduce. Then banks are able to eliminate the chances of forgery. In those days, there were all these cases of people stealing people's signatures and all that. But today, with BVN and electronic forms of withdrawing money, it is really difficult for signatures to be forged today. Even when you have signature and you go to the bank to withdraw money, usually with a check, the bank will insist on a specific form of ID card. They want to see you, make sure you are actually the person that is being spoken of in the check or in the document that you want to withdraw money from. And if you go to withdraw money from an account that is not yours, posing as the account holder today, you will very likely end up in jail because even the bank has stored in their archives electronically whenever they call up your name on their system electronically, they can see a they can see a version, right, of your passport, of your photograph with them. Now, today, BVN has simplified the process of localizing the details of a customer within a bank. So BVN has done that. Before, banks are required, usually in the bank that you open your account in. That is why many times when you want to, in those days, in the 50s, many of you have not been born then, in the 50s, when I was there, usually if you want to do some transactions, you want to change your name, you want to do many things with your bank, you will be referred back to the branch of the bank where you opened your account. Somebody is in Kaduna, he wants to change details, they refer him back to somewhere in Delta State or whatever that you open the account. Why? Because your details are localized there and it's easy to from there change it and then produce copies that are shared with the head office. But today, you can change your details from any bank branch because of the internet. Okay. So the bank is required to have information apart from the specimen signature. You should have information on whoever is your customer. Today, in order to open an account, banks do what is called KYC, which is know your customer. They come to your house. Normally, they don't do that anymore. Some of them are too lazy to actually stand up and go to the person's house. So they ask you questions like, what is the landmark close to where you live? What is the color of your zinc? This and that. They are not supposed to ask you those questions. They are supposed to actually leave the bank, go to your house and be sure you live there in case, you know. But then, as we said, a bank is required to take information. Now, if the customer of the bank is not a resident person, is not a native of the place, let's say somebody from the UK gets a job to teach in OAU, right? He wants to have a bank account in Nigeria. The bank will require details of his passport and other traveling documents that he may have. All right. So these are important issues in opening a bank account. Um, Opening an account, any legal person can open an account. Legal person includes, according to Clinton, natural and non-natural legal persons. Okay, I've never had that one before. That's good. The bank should make sure they know the person desiring to open an account. This will protect the public, the bank, and the person in question. So if you do not open an account with somebody you know, people may be defrauded through the account because you wouldn't even know the person. It will be difficult for you to locate that person. Another thing is the bank account is a prerequisite for a banker customer relationship. And as we will see, there are different forms of bank accounts and there are different documents which the bank is required to have, depending on whether the individual or whether the customer is a natural person or a non-natural person. Okay. So if you're a non-natural person, thank you, Clinton. I'll keep thanking you till this class is over for giving us this wonderful classification. If the person is a non-natural legal entity, or is even entity he put, I thought this person, you have to supply the memorandum and articles of association and other binding documents which the bank requires. If he's a human being that is natural, you just provide identity documents. The memorandum and articles of association, the minutes of the meeting where a particular employee of the bank, of the institution, of the non-natural entity has been given the authority to open bank accounts on behalf of the bank, and other things that are incidental and necessary for running an account is required to be provided. Okay. So what are the types of accounts? There are different ways you can classify an account. You can classify an account according to the special designation of the customer. So we have things like a business firm account, a trusteeship account. These are special designation of the customer that leads to the kind of classification of accounts in that regard. You can also classify an account according to the subject matter of the account. So if you are being paid into this account, you can call that account a wages account or a savings account or a current account or whatever account. Also, generally, there are two forms of accounts. Generally, there is the deposit account and there is the current account. Usually, when I teach this, I first point out the fact that there are two general forms of account, a deposit account and current account. Many of the other forms of accounts can fall into any of these categories. There are so many forms of account if you check the textbook, legal practitioner's account or this one, that one. But whether it's a joint account or legal practitioner's account or whatever form of account, majorly they can either be a deposit account, which is an account where you deposit money and allow it to stay for a while, or a current account. A current account is generally regarded as a checking account. A checking account is a bank that has a check on it, which allows for third-party withdrawals. With a check, you can give instruction to a third party to withdraw money from an account. So accounts that have checks in them are called current accounts. In those days, when the distinction was clear, people desiring to save money would put their monies in a deposit account. You know, they don't come all the time to take the money from it. Where you find this kind of, if you've traveled outside the country and you open an account, usually you understand this. Their savings account is the account where you put the bulk of your money, and the current account is the account where you have a credit and a debit card on. So it's easy for you can transfer money from your savings account to your current account. Okay. So when you are now spending your debit card or your credit card on your current account, you don't put so much money inside your current account. That's basically what I'm trying to explain. You don't put so much money in there. You put just the amount of money you want to be spending. That's an account that is always, necessaries, the things if you want to go cashless, you can't be carrying a debit card on an account that has all your money inside. It doesn't make sense because you don't know where you swipe the thing and all your money will go. Or you buy something online and they will carry your details and put somewhere. I know some of you don't have money, but people that are actually rich, you know, like Clinton, they don't put all their money on the account that have their credit card on or their debit card. But if your debit card just has, if your debit account or your deposit account just has 2,000 or 800, or for some of you, 200, then there is no point having two accounts when it's only 200 naira that you have. But if you are rich, like Clinton, and in your account you have up to 3 million, you cannot carry a card and have 3 million and just be carrying the card of a 3 million naira account everywhere you're going. It doesn't make sense. So people who want to save money will put the money in a deposit account. The money they wish, the change they want to be spending, they put it in a current account. So they can write checks on that account. Banks prefer a savings account to a current account. You will see part of the features of the current account as we go and you understand this better. Now, the forms of account that we have now in Nigeria, the modern forms of accounts, that one I talked to you about now, these classifications I gave you are not really just for textbook purposes and for writing your exams. But then if I'm going to say these are cake forms of accounts, nobody thinks of it. There are still legal practitioners accounts, there are still trusteeship accounts and all that, but nobody actually calls them that. So these are the forms of account that we have in Nigeria today. We have, of course, a savings account, which is what many of you have. The savings account of today does not have the same meaning as the savings account of those days. Savings account of today is a money where you put money and you can call it up, and usually has a limit of like 50,000 or 500,000. A current account, of course, it has remained the same, which is it is a checking account, an account that has a check attached to it. In both of these accounts, usually customers of the bank don't get any interest, okay, except where they place an amount of money, that by law, anybody that has that amount of money in any bank must receive interest. So that's what happens here. Now, fixed deposit account is what banks love so much. That's where somebody puts money and says, I will draw this money in 5 years, or in 30 years, or in 50 years, you know. So fixed deposit account is part of the things that banks sell because it ensures liquidity for them. This is the money that they know that for the next 3 years, the owner will not want it. So they can use it to do business. They can use it to give loans. They can use it for anything that they want to use it for. So other kinds of accounts in Nigeria today, a joint account. Usually your father and your mother has a joint account. Clinton and his girlfriend has a joint account. And many of you do have joint accounts. A corporate account, organizations have joint corporate accounts, for example. I know many of your organizations have corporate accounts. You have associations that the president and the secretary would have to sign to receive money. So that's an example of a corporate account. Big businesses also have corporate accounts. A domiciliary account is an account that allows the holder in Nigeria to trade in foreign currency or to withdraw foreign currency directly. So a domiciliary account, if someone sends you a dollar, the dollar will enter your account as dollar. So when you go to the bank, what you're withdrawing is dollar and not naira. Okay, it doesn't convert to naira. It's a domiciliary account. You can put dollar inside. Now, a non-resident Nigerian account, that is somebody who is not resident in Nigeria. If you are a Nigerian but you live in the UK but you want a Nigerian account, there is an option for you to open an account of that nature. And then many other forms of special accounts. What are these forms of special accounts? There are so many of them. Many of you are talking about CUDA. Many are talking about accounts that you can even open without putting any amount of money inside. They are there now. You don't even need any money to open an account. In those days, I remember when I opened my first Diamond Bank account, that was in 1953. I had to deposit 25. You had to deposit an amount of money to open an account. But today, you don't need it. Just supply your details, and account is open. All of those things are special accounts. There are many forms of it. So why am I specially treating a current and a deposit account? I'm treating them because in your exams, this is how it will take. They will be majorly asking you questions about when they want to tell you to distinguish accounts, they will tell you to distinguish between a current and a deposit account and things of that nature. So I gave you three features here. A current account holder withdraws his money using a check. A current account does not yield any interest except where the law requires the bank to pay interest. A current account may either be in debit or credit. That is to say, it's possible for a current account to be overdrawn. Overdrawn means it's possible for the bank to know someone's spending limit and know that this person has overtaken the spending limit, but due to the fact that this is a reputable customer that has regular cash inflow, the bank can give that person um, what is referred to as an overdraft. So when you have a check, even if you don't have money inside, you have an overdraft limit. So if, for example, you are always lodging 5,000 inside and you have 5,000 regularly deposited in your current account, the bank can give you an overdraft of 2,000. So when you now give somebody a check of 5,000, give another person a check of 2,000, the check will not bounce. However, your bank account in that period will be in debit, and the relationship between you and your banker will now be debit, a debtor creditor relationship where the banker is the creditor and you are the debtor because you are owing the bank. Okay. Now, Okay, I'm seeing a message from somebody that they cannot hear me. Can others hear me? Okay. Probably I wouldn't know how to solve your problem. You may have to enable your audio in order to hear me.
So you actually went off at some point.
Okay. At what point, please?
That's why. Before you came in with deposit account, but it was kind of like just in a minute, yeah. So you came back again.
Okay, but you heard clearly everything I spoke about current accounts.
Yes, sir.
Okay, good. That's all right. That's all right. So the next thing is a deposit account, which is essentially a savings account, is where you save money. Savings means save money. You put money in a deposit account. Usually you are issued a passbook. Of course, many of you think, oh my God, what's a passbook? People still get passbook in this 21st century? Yes. Okay. But I'm not sure they still give passbook. But then I remember they gave me a passbook for an account I opened, but I've not opened any more recent accounts though. But I'm not sure they still give passbook in this 21st century. Who needs passbook? Okay. But passbook is a document they give you that you will use and withdraw money from over the counter. Okay. In those days, but now if you go to any bank, there's withdrawal this thing in banks now. So they drop money in case you want to withdraw over the counter. You don't need to carry your own passbook and come. In those days, if you don't have your passbook, you have to buy another one. Echo Bank. Oh my God. God, please. Don't allow those people Echo Bank to make it. Because Echo Bank, hey God. There was a time I said they are the worst bank in this country. Yes, withdrawal slip, deposit slip are now in banks. So no need for passbook. But in Echo Bank, they will say you buy a new one. In those days, thank God, Sha. Now we have ATM, so no need for all of that. So a balance in a deposit account always attract interest. But then I'm not sure a bank in Nigeria has ever given somebody an interest of up to 1,000 naira. I don't know anybody that's ever gotten up to 1,000 naira in interest. The interest they usually show me is in 5 naira, 20 something naira. Wait, is it because my money is not in millions? Probably. Maybe if I deposit 100 million, they will not give me an interest of 1,000 or something. But then you should know that um, I know some of you hate me. You think I'm broke like you people. I'm not. I'm not broke, okay? Okay. Know that and know peace. Now, just know that your deposit account is supposed to attract interest. It's supposed to attract interest. All right. My last slide here talks about other forms of special accounts. There are so many of them. The group that is presenting would have to look into all of this. Pay close attention to a joint account, right? I know why I'm saying this. The spirit is talking to some of you now that uh, you are supposed to know this. Pay close attention to joint accounts. Oh my Lord. Usually because it shows up in exams all the time, but also because you should know it. Joint accounts have rules about survivorship. That is, when someone dies, there are very intricate um, things about joint accounts that you need to really know. They are very, very Very, very intricate things about joint accounts that you need to know. One of them is that there are three situations where a joint account can arise. A joint account can arise where more than one person opens an account. Okay, that is one way that a joint account can arise. Another way a joint account can arise is where two or more persons open an account for another person. You get what I'm saying? They open an account for another person or persons in that other person's name. That is another way a joint account can arise. A third way a joint account can arise is where a third person opens an account in the name of two other persons. Now, you know that when you are being graded, when your exams come, we will not be asking you, tell me what is a joint account and blah, blah, blah. We will very likely be showing you a scenario, okay? In that scenario, you'll be able to distill the issues and take care of them. A joint account is a joint contract with the bank, and the bank will have to treat the two parties in a joint account as one. Okay, where there is liability, the two parties will be liable. The bank cannot treat one party without also making the other party to know. Now, you see all these questions where one person in a joint account will go and change the details of the joint account. Now, I watch those things in movies and I wonder how that is possible. However, what is possible is that two people, when they are opening a joint account, can make one party the drawing party. That is to say, they can designate one of the parties as the party that will be withdrawing money for them. Except in such an agreement, the two parties will have to withdraw money together. The right to withdraw must be exercised jointly by the both of them. Also, um, it is illegal for a bank to eliminate one person in the chain of communication and be relating with only one person. In a joint account, because it's a joint contract, when the bank wants to give an instruction, the obligation is on both parties. And when the bank will receive an instruction, it is the two parties that must give the instruction, except where one of the party dies. Now, whenever there is death in a joint account, and that is how, if you ever have a parent that has pushed away the other in a joint account, know that there was usually they will have to supply the death certificate of the person. So if one party dies, the other party survives him or her. That is to say, all the money in that joint account moves to the next person. So it is not money that another person will go and take. No. There are so many cases that you have to read to illustrate this. I would suggest that the people presenting tomorrow should maybe give one person this topic, joint account, let the person really read it. It's a minefield and you enjoy it a lot. Another thing that we talked about here is a partnership account. A partnership account arises from the nature of the partnership agreement. So it is the partnership agreement that will say this person is the person that has the right to open an account for the partnership. Is the person that will serve as the partner that will be receiving instructions from the bank. Now, it is by virtue of the partnership agreement which we decide how the bank will relate to the customer. Now, by virtue of the Partnership Act, which is a received English law, if you read page 107 of Igweike's textbook, you see English Partnership Act of 1890, which is a received English law. If you paid attention in your legal method and legal system, you will realize that every party in a partnership, except in the case of an agreement to the contrary, has the right to open an account for the partnership. Now, if the partnership is dissolved, nobody has the right. A surviving partner cannot say it will not go and take the money from the account. No. The money in the account, when a partnership dissolves, is used to wind up. Am I audible? If I'm audible, just let me know. Anyone?
Yes, sir.
Thank you. The money in the partnership is used to wind up the partnership. What does that mean? Ask yourself, what does that mean? The process of winding up is a process of, what do you call it now? Liquidating a legal or a business. Now, you know that why a partnership will go into, what are the reasons? Let me ask some of you, what are the reasons that will make a partnership to die off? What are the reasons that will make a partnership to wind up or liquidate? Um, Maybe they don't have any money. Maybe they don't have customers again. Maybe one of them is getting married and maybe anything has happened, right?
Maybe they are selling off.
Exactly. Maybe they are selling off everything they have. Now, the point is usually they are owing somebody. The money from the partnership account should go into settling the debts. It doesn't mean that two of you share the money and run. The things that are required to do in order to wind up the partnership, the money should go into that. It's not that the money immediately becomes the property of another person, you know? So another form of, I've overshot 1 hour and I'm really not glad because I know you are buying data and all that. So I'm going to run through this. The rest of this, when we come tomorrow, they can pay attention to them. But yeah, just know about this. The rest of them is not really that complicated. The trustee account is an account open for a beneficiary. Okay. If the bank knows that the account is open for a beneficiary, it has to handle it with care because that means that the beneficiary is going to come of age soon. And it's important for the bank to know that this account is for that purpose. There is also an executor's account. An executor is somebody that handles the affairs of somebody that is dead. All the money as a lawyer, you could be an executor to somebody one day. You handle the letters of administration, a person that has money in banks and all that. You have to handle it for the person. All the money you recover may be placed in an account that you open specifically for that purpose. That account is an executor's account and it should be, after dealing with settling all the expenses you incurred, should be returned to the family. A legal practitioner's account is an account run by the office of a legal practitioner, right? It doesn't mean that when a lawyer opens an account, it's a legal practitioner's account. No. A legal practitioner's account is where monies, for example, judgment debt. If you go to court for your client and he wins money, the money is put in that legal practitioner's account. You should handle it in trust for the people that need it. Money should not go from that legal practitioner's account to your private account. Otherwise, it could be fraudulent. Also, when your client is supposed to pay for damages or money that is in dispute and all that, I can give it to you, put it in a legal practitioner's account. it is not your money. It's not, it doesn't refer to an account opened by somebody who is a legal practitioner. Pay attention to that as well. Also, a limited liability account follows what has always been talked about. You have to look at the memorandum and articles of association. Also, there are particular things that happen when the company is winding up and things of that nature. So, yes, so this is where our discussion on special accounts close. I will also teach you again before Monday by the grace of God. And yes, we will know what we'll do from there. So thank you very much. This is the end of today's class. Let me see if anybody has any question that they want to ask me. What? Blessing says I should address you people on legal aspects or absects of bank accounts. Okay. Um, you know that when we talk about legal aspects of an account, that means what we are talking about. This is a law class. Okay. The things I'm telling you are already law. Okay. It's not because I'm not saying in the case of so and so. It's not my responsibility to be giving you cases upon case. I don't teach like that. I don't teach in a way that somebody will be bouncing off cases. You know, there are some of my friends that do that. I don't teach like that. You would have noticed. I teach you so that you understand. If you understand it, you now use that mindset and go and read the textbook. Inside the textbook, you are going to see cases, you are going to see sections, you are going to see all these things. With the understanding you have from talking with me in class, it's easier for you to understand those things. Is that okay? So I will not be saying in the case of, maybe that's what you mean by legal aspect. But what I'm teaching you, what I'm talking to you about bank accounts, this is law. When I say a legal practitioner should not move money from a legal practitioner's account to his private account, there is actually a case where a legal practitioner did that. Okay. And he was held liable for fraud. I also mentioned that if he does something like that, it is fraudulent. So I understand you are not used to maybe my pattern of teaching. Probably you get used to it as we go on. But you must know that the things I'm telling you are law. They are not my ideas or they sound cool. No, this is the law. And if you read your textbooks, you check the cases, you are going to find the legal authorities that you need. Now, when I ask questions, my own questions usually, I like you to talk about them like somebody who understands it. Okay. Now, some of you know that I am not the one in charge of this course. So you must put the law for them and answer them their questions the way they want to answer. But understand it from my teaching. Understand it. All right. So who is a holder in due course? A holder in due course is a person who takes a negotiable instrument. Usually you find this in parties to a bill of exchange. And he takes that bill of exchange in the ordinary course of business, right? For value. A holder in due course takes a bill of exchange in the ordinary course of business for value. So what is an ordinary course of business? Now, if, for example, in the way business is done, an example of a business of a negotiable instrument I gave you is a bill of exchange. But then I want to use an example that many of you will require. That is money. If, for example, you walk into a market and you take money from your pocket and give to a fish seller who gives you fish, that is the ordinary course of business. That is how business is supposed to be. If you give that person money and that fish seller collects that money from you, normally everyday business, and then you come back later, somebody now is holding you by the trouser, and he's like, this boy, you stole this money from me and use it to buy fish. Fish seller, give me back my money. Fish seller will say, no, I will not give you back your money. Even though the person who gave me this money has no title to that money, I cannot give you this money because I exchange it with the person in the ordinary course of business. I have the right to this money. Do you understand, Wonder? That person who is holding that money, the fish seller holding that money in a market, is a holder in due course. Why is he a holder in due course? He gave you money, you gave the person money in the ordinary course of business. She exchanged that bill of exchange, that negotiable instrument you've given her, for value. What is the value? The fish you have in your hand. Now, of course, this is a very basic example. There are more complicated examples out there, but at least you understand it. So if, for example, people are trading on an exchange in the market, right? Stock market, that's also something that can happen. This example can grow in complexity. All right. So that's about that. Do I have any further questions? Otherwise, I'm going to end this class. Do I have any further questions? Okay, Clinton, remind me of the things I said you should remind me. And I will see you tomorrow by 6
All
p.m.
right.
Okay?
Okay. All right. You said I should remind you that you want to
No,
text
not
the
right
professor.
now. Like, remind me on WhatsApp.
Oh, okay. Oh, okay then.
All right. Thank you, guys. Bye bye.